Hello everyone, myself Mansi Asija, and I'm working with LEXIS and Company. Again, uh, was this channel, and my today's topic is res subjudice. According to you, what does it mean? Res subjudice. In CPC, Section 10 deals with the doctrine of res subjudice. Res means matter or litigation, or subjudice means pending under judgment. With these two words, it implies that the rule of sub judice relates to a matter which is pending judicial inquiry. In other words, you can say this rule applies where a matter is already pending before a competent court for the purpose of adjudication. Section 10 of CPC deals with the stay of civil suits. Uh, what is stay of suit in under CPC, under res subjudice? No court shall proceed with the trial of any court in which the matter in issue is also directly and substantially an issue in a previously instituted suit between the parties, or between the parties under whom they or any of them claim litigating under the same title, where such suit is pending in the same or any other court in India, having jurisdiction to grant the relief claimed, or in any court beyond the limits of India established or continued by the central government, having the having like jurisdiction, or before the Supreme Court. Uh, let's talk about the ingredients of Section 10. Number one, court shall proceed with the trial of any suit in such it is such court where subsequent litigation has been instituted, and not the court which has taken the adjudication for previous litigation. Technically speaking, Section 10 applies to those litigations which come within the ambit of Section 9. It is read with the Section 26, Clause 2 of the Code. The term trial in this sense implies to all the proceedings of a civil suit. So the litigation needs to be stayed not with the notwithstanding the stage at which it is. Uh, it were intended to bar the separate trial of any suit in which the matter in issue was also directly and substantially in issue in a previously instituted suit between the parties. But these do not apply to the simultaneous hearing of late and earlier suit after the consolidation of the two. Suit with the meaning of Section 10 includes a pending appeal, and even if second appeal is lying undecided, it is previously instituted suit for the purposes of the section. Second ingredient, matter directly and substantially in issue. It means, according to you, what is matter in issue under Evidence Act? There are two types of matter directly and substantially in issue. Directly means immediately without intervention, and substantially implies essentially or materially. Second is matter collaterally and incidentally in issue. Uh, now, and what second ingredient is says matter directly and substantially in issue. It means the rights litigated between the parties, that is, the facts on which the right is claimed, and the law applicated to the determination of that issue. The words matter in issue used in Section 10 does not mean the entire subject matter of the subsequent suit, and the previous suit must be the same. These words mean all disputed materials quotient in the subsequent suit, which are directly and substantially in quotient in the previous suit. Now, third ingredient, same parties. इससे तो समझ आ ही रहा होगा कि सेम पार्टीज क्यों बोल रहा है. The previously instituted suit must have been a suit between the parties or between the parties under whom they or any of them is claiming. Party is a person whose name appears on the record at the time of the decision. Fourth point, same title. Title should be same. It means same capacity. Title refers to the capacity or interest of a party, that is to say that whether he sues whether he sue or he is sued for himself in his own interest or for himself as representing the interest of another. Now, fifth ingredient, previously instituted suit must be pending. अगर previous वाला instituted suit is pending, then the previously instituted suit between the parties must be pending on first, in the same court in which the subsequent suit is brought. Second, in any court in India. Third, in any court beyond the limits of India established or constituted by the central government. Fourth, before the Supreme Court. Let's take an example. A, an agent of S at Jaipur, agreed to sell S goods in Bangalore. A, the agent filed suit for balance of accounts in Bangalore. S can sue the agent A for accounts and his negligence in Jaipur, while case is pending in Bangalore. In this case, Jaipur court is precluded from conducting trial and can petition Bangalore court to direct stay of proceeding against Jaipur court. Um, let's talk about nature and scope of section 10. It declares that no court should proceed with the trial of any suit in which the matter in issue is directly and substantially in issue in a previously instituted suit between the same parties, and the court before which the previously instituted suit is pending is competent to grant the relief sought. This rule applies to a trial of a suit and not the institution thereof. It also does not preclude a court from passing interim orders such as grant of injunction, appointment of receiver. It, however, applies to appeals and revisions also. Uh, According to you, what is the object of this? The object of this rule contained in Section 10 is to prevent courts of concurrent jurisdiction from simultaneously entertaining and adjudicating upon two parallel litigation in respect of the same cause of action, the same subject matter, and the same ruling. The policy of law is to confine a plaintiff to one litigation, thus obviating the possibility of two contradictory verdicts by one and the same court in respect of the same ruling. Let's just take let's say in a simple term, where two cases are filed between the parties on the same subject matter in two different courts. The competent court has the power to stay the proceedings of another court. This is called res subjudice in the simple term. What are the condition of section 10? Let's talk about. First, there must be two suits, one previously instituted and other is subsequently instituted. Second, the matter in issue is a subsequent suit must be directly and substantially in issue in the previous suit. Third, both the suits must be between the same parties or their representatives. Fourth, the previously instituted suit must be pending in the same court in which the subsequent suit is brought in, or in any other court in India, or in any court established or continued by the central government or before the Supreme Court. Fifth, the court in which the previous suit is instituted must have the jurisdiction to grant the relief claimed in the subsequent suit. Such parties must be litigating under the same title in both the suits. Right. Um, some questions frequently asked that whether the court can pass an order of consolidation of both the suits. Since the main purpose of Section 2 is to avoid two conflicting decisions, a court in an appropriate case can pass an order of consolidation of both the suits. Um, Second question, whether the decree passed in contravention of Section 10 is a nullity. A decree passed in contravention of Section 10 is not a nullity and therefore cannot be disregarded in execution proceedings. This is a main doubts of the Section 10. I think you got it. And thank you for watching this video, and thank you for subscribing this channel. And if you didn't subscribe this channel, please subscribe this channel and this and like this video. And thank you.